Hello. Uh, I think should be working. Let me see what it's saying. Live stream is working. Chat, let's see. Okay, looks like it's working. We see some messages. I think I'm not able. I don't think I'm able to figure out like how to get it live on the other channels like LinkedIn and all. Outside of that, I think it's pretty much working. I think it's just like something is wrong. Um,
Okay.
but outside of that. Hey everyone, thank you for joining. Great to have you. I think Steve, maybe we can just get started on this, and this is like going to be a decent amount of time. So I think we should probably like maybe give some overview,
Okay.
um, and then we can get into like some of the categories, the new guidance, and I mean, if there are questions, then we can take those questions. Um, One
Sure.
question I see is like you should see settings for live stream. So actually, when I was doing it, it was showing me that it's going live stream on other places, but somehow it just like went away just now. So there is some, I think it might be bug. It's fine. We don't need to worry about it. It's getting recorded too. Um,
I think we need an IT specialist for these to administer these sessions, you know.
yeah. Okay. Awesome. Let's get started.
Yeah, I think it might be useful for those of you out there who don't know about O1. And Atalo and I always say this, we prefer to have the questions asked to us than for you guys to be looking online for information because this is a constantly moving target. And I think it's important, Atal, that people understand that. The law hasn't been rewritten since 1986, but it's constantly being updated in terms of how it's applied. And there's guidance out there that helps us as practitioners anticipate what those new wrinkles are. We just had for the O1A and O1B categories on January 8th, there was new guidance that was put into effect by USCIS that's published. It's public information. And now the cases that my firm has submitted in the past 3 4 weeks, we've started to get feedback and to see through what are called requests for evidence what how they're applying the law now with this new administration. And so I think that's why it's important for people to understand all the basic concepts, but then we can also give them some sort of hacks or ideas as to how to engineer the cases in a specific way, right? And that's the real challenge here. It's not black or white ever when it comes to the interpretation of these laws.
Definitely. So let's get started on all these topics, Steve. But first,
Okay.
like maybe a little bit of background about you. I mean, I know you for like a while now, have done a lot of events with you where you have spoken about how you feel like, passionate about immigrants, helping immigrants, and especially bringing more entrepreneurs. I think this session is very much aligned to all those. I think a lot of people on the call here are either entrepreneurs who are looking for O1 or people who want to be entrepreneurs, be it like about O1A via agent route or O1A directly through their employer. So I think this is like a great session. So maybe like we can give a quick overview about the type of cases you look at and what and your experience in this area.
Yeah, I mean, the first thing I tell people is that I'm an immigrant, right? And I'm also an entrepreneur. I'm originally from Argentina, and I had to go through several different immigration processes when I was brought to the US by my mom because of this strange gray area in the law that said that if you are a US citizen but you didn't live in the US as an adult, you can't get your child an automatic passport when they're born overseas. So when my mom and dad split and she brought me to the US, I had to go through all these different processes that I don't really know exactly what they were, but it piqued my interest in understanding immigration. And then eventually I went through the same thing that a lot of people go through. I got out of Georgetown Law School and I got a job that I had to take to pay bills. And then there were layoffs, and I was one of the layoffs because I was one of the new attorneys. And I realized I didn't want to be an employee anymore. So I moved back to Argentina. I did something that was very unconventional. I went back home and I launched a US immigration practice back in the beginning of 2004, so 21 years ago, almost to the day. And I was forced to learn a lot of immigration on my own, and I quickly realized I was the only US immigration lawyer based in Argentina, and this was pre a lot of the technology that exists now. So people really wanted to see the lawyer face to face. And so I was the only person that could help a lot of these people. And I started doing a lot of investment based cases. One of my first cases was an O1. I was the first attorney that I know of to get an O1B visa for a tattoo artist. I think that was 2005 or 2006. And people told me, you can't get it for this. And I still got it. And I realized that if you prepare well and you craft the cases well, you make solid arguments, you can get O1s for a lot of different people. And then I gravitated to doing more and more entrepreneurial based O1s. And we do a lot of E2s as well, but the focus of today is O1's extraordinary ability visas. So I've done somewhere between 400 and 500 of these cases over the years, and really developed a niche in working with founders. And I want to say one thing. One thing that's great about the new policy that memorandum that came out is it officially acknowledges that USCIS will accept cases where there are sole founders, and that's an important change. In the past, they wanted objectivity in hiring, they wanted co founders, board of directors, etc. Now they are accepting cases where someone sets up what's called a C corporation or an LLC, which is a limited liability company, and they can essentially self sponsor now through the O1. We haven't submitted one of those yet, but we're working on one. And I think that's important because a lot of people want control, right, Atal? And we talk about self empowerment all the time with the visas that we do. One way to avoid now having to depend on others or being voted out by a board of directors or being dependent on a company sponsor, which is why I use an agent, you have the option of setting up your own company, which allows you to self-sponsor through that company, and that's another way to empower yourself. So that's the first thing I wanted to mention about the changes that are in effect. I think that's really exciting news for a lot of people.
Yeah, I think a lot of people on H1B were very much like, trying to figure out a pathway on like first of all working for an employer and then trying to have their own company. So looks like USCIS is now more acceptable to people who want to do their company, and O1 is the path they're suggesting. Because I mean, I saw the pretty much like another thing about H1B as well, that hey, we have changed the regulation and you can start your own company. I mean, from a regulation point, I see some movement for sure. Like, but I mean, how are you seeing
Yeah,
overall?
there's subtle differences, right? The H-1B, you can port it. It's called it's a porting or transferring the H-1B, but there's an issue called ability to pay, which means that if you start your own company and sponsor yourself for H-1B, you have to have enough assets in that company to be able to pay a salary, which is also the minimum salary is actually decided by Department of Labor, and those salaries can be quite high. So it can be very restrictive to do H1 self-sponsored, whereas O1 you will have to pay yourself a salary, but it's not there's no specific number given to you by Department of Labor that makes it harder to get those funds in place to be able to show. The ability to pay focus is not the same. And so I think there's more flexibility with O1. The other thing, of course, is that when we do our cases, we are always looking towards EB1. So if you can easily transfer an H1B, let's say because you have a specific degree and your position matches the degree, and that position requires generally that degree. Those are the requirements, right? You don't have anything that will get you to quickly a green card. And that's the beauty of EB1A. Everything that's in an O1A category, and if anybody has questions, we'll answer them later. But essentially, the great thing about O1A, which is for anyone who's not in an artistic field, which is O1B, there are 8 categories, and those 8 categories are directly translatable to EB1. So every time you build evidence for an O1 case, you're simultaneously building a green card case, which can be self-sponsored, and so there's no effort lost there. So I think that this is really positive news. Atal, especially for people in H1B, because what you're worried about in H1B is how much time you have left, whether the sponsoring company is sponsoring you for a labor certification or not. Will they wait till the last minute? Will they pull the sponsorship? This allows you to be in control of your own destiny, right? And you can also, it's sort of an interesting thing about it is you can apply without even notifying your current H-1B employer. If you're approved, then you go into O1 status effective the date that you put in the petition, which can be any time from today to 6 months from now. And so that allows you to take that chance without any risk, really, because if for some reason you don't get the approval, you're still in H-1B status. You don't lose it. And so it allows you to build things organically, systematically, apply, get an approval, and then you can say, I'm giving my notice, and in 2 weeks I'm no longer working here, and you're already transitioning to O1 status.
Got it. I think, yeah, thanks for sharing that. I see a lot of other questions about H1 versus O1, and we can go over all these.
Let's
But
do
I
that
think
at
maybe,
the end.
yeah, let's do that at the end. Maybe we can get started with like, just going into details about O1 and what we are seeing in terms of like the recent updates from the USCIS officers about like, okay, what is getting approved, what is not getting approved, and in a way, like, people are looking to build their profile, people are looking for O1A agent and maybe like more of guidance. So let's start with O1A, like basic criterias and how can someone get towards it.
Okay, so what we're seeing in terms of trends, and this started with the previous administration, is an absolute literal interpretation of the law. What does that mean? That means that they are applying it exactly as it's written. So we just recently saw a case where there's a category for O1A and O1B, which is critical or lead role in an organization of distinguished reputation. So in the past, the way it was adjudicated was if you had a previous role in a distinguished organization that was critical, you could be approved based on that. But now, because the regulation says has and will have a lead or critical role in an organization, they are now forcing you to show that your future employment will also be with a critically acclaimed or distinguished organization, which is much more challenging. So that's a strict enforcement of the law that we're seeing now that will make it a lot more challenging. They're also using that to cross over to OMB, what's called leader starring role in productions or events. They want to see that the person's future events or future performances will also be with productions of distinguished reputation, and then that makes it more challenging, right? How do you prove the future? And now, what we were going to have to do for all the cases that we're currently working on and future cases for entrepreneurs is show that their future employer, which is oftentimes their own company, has a distinguished reputation. And then there's a list in the guidance of different things that you can use to show that. One of those is funding. So, this is where funding has shifted in terms of where you use it. I think this is very into the weeds at all, but we've seen previously that funding is now discouraged for approving awards. That's no longer accepted. And if people don't know this and they're reading old information, for the awards category, they do not accept funding anymore. So funding now can be used to show that your current and future employer, depending on where you are physically, for that category of critical role in an organization, can be used to show the distinguished reputation of that organization. So they
So I
split.
think, yeah, just so like, we go a little bit more on this distinguished reputation for the critical role. When we are talking about O1 visa, I mean, a lot of people who apply are like startup founders.
Yes.
When we say organization as distinguished, a lot of the distinguished organization that we used to prove is like something which is very big and is already creating a lot of impact, which is like already a successful and has a lot of media presence. So how do you think like, these new organizations that people are starting as startup founders fit into that distinguished organization part? How do we go about that?
I think that what this means is you need to take more time to build that reputation before you apply. And I never encourage people to apply quickly. People are in a rush because they're excited to get more funding or to do more things to direct and develop their businesses. But if they don't get the visa, then they're not going to be authorized. Then you see them taking chances, going in with a B1, B2 visa, which is a temporary visitor visa, or the ESTA visa waiver program, and doing things that they're not authorized to do yet. And that's dangerous, right? So what you have to do is balance here. You have to understand that this is almost an additional requirement now. The way that they're interpreting it used to be has or will. So what that also means is that if you've never worked in a critical capacity before, then you have to show that you're doing it now, right? Maybe from outside the US in a different capacity for the company, which means you need to be an independent contractor for your company, but from overseas to show that you have been having a critical role. And then in the same letter that confirms that, talk about the will. The reputation part is the one that's not really defined. So the guidance is helpful. It says funding can be included. Media is very important, and I'll sort of beat this over the head. Media is the most important category in these petitions. Unless you're a scientific researcher with patents, citations, and scholarly articles, those are the people that don't usually have media coverage. But media coverage here is important because it not only talks about you as being at the top of your field, but it distinguishes the reputation of the organization, right? By mentioning it and by having it appear in different media in different parts of the world, perhaps. So that's another thing. So size of funding, any media coverage, and then they're going to look at the trajectory of the company, who it's working with. I think the guidance is also interesting in that it talks about what getting letters from government agencies. That doesn't have to be U.S. government; it can be any government. But if there's any government involvement where they can say we are working with or we intend to work with this company, that also lifts the reputation of it. So I think you can't just bootstrap your company and have no media coverage about it and say, give me this visa unless you have other categories that don't require you to qualify in critical role. And that's what it's important for people to understand that there are 8 categories. You need 3, right? Minimum. Doesn't mean you have to have all 8. A lot of RFEs I get from other lawyers where I evaluate the cases that they've submitted, they just try this kitchen sink approach where they apply for every category and try to make arguments about each one. That diminishes from the strength of the petition itself, and people need to understand that it's a holistic interpretation of the evidence that they're doing in the adjudications, which means if you bring in something just to throw something at the wall and see if it sticks, it makes your entire case look worse. And they're going to look more in depth at the other categories to try to break them down. So it's better to have 4 really strong categories than 3 strong ones and 5 weak ones, if that makes sense, right? You can't try to fix everything. You need to have meet that threshold for each one. So in this case, people shouldn't be alarmed if they haven't had previous experience. They may not qualify under the new interpretation of critical role, which means they have to bolster the other categories. This is a holistic view that you have to take, and you have to understand what each category is, what you need to prove it, and if you're working with the right attorney, they will know which categories to use and which ones not, because it looks really bad when you present categories that have nothing, no legs to stand on.
Got it. So we kind of went into a little bit about the how the critical role criteria is met. So that's like one of the criteria that is for O1 visa.
Mm-hmm.
Let's go more into like the awards criteria now. I think I think a lot of people, as you said, used to use funding as a way for awards, which is now changing. How do you feel like, people can qualify for the awards criteria?
Yeah, I think that you're basing it on the reputation of the organization or institution that is giving you the award. So if they're well known, either institutions or academic, or sorry, professional associations, then that's a good start, right? If it's Uncle Bob's, AI technology award for 2024, it can't be something that's brand new. It can't be something that's invented. The more trajectory it has, in other words, how much history it has. Part of the requirements for an awards is to cite specific prestigious former winners of the award, right? To show it's very selective and prestigious. If it's been around for 20, 30 years, it's going to have more weight than something that's brand new. That's the first one. Um, they expanded the definition a little bit to include things that are on a doctoral level. So we have some people that are maybe doing their PhDs, and PhDs are people who are quasi-professional academic, right? So they've now said that those dissertation awards and scholarships can be included. And then also conferences. Conferences are massively important, and that's been consistent through all these years I've been doing this. Where if you are presenting a paper at a conference, that can be used for scholarly articles. If you're reviewing articles that were published for a conference, that qualifies you for judging. And if you've won an award at a national conference or international recognized conference, then that also qualifies you under awards. So international and national scope is one of the most important things to keep in mind when it comes to distinguished reputation of an organization, an award, a judging. If you've judged an event that's national in scope, that is constantly something that they use in their guidance. And then you need to make sure that the confirmations for these awards include information that's required, like the criteria used to grant the awards, the significance or international scope, then the number of people who have won, the list of winners. If you're working with someone on these cases, they need to know what has to go in these letters. For our cases, we have sample letters for every category of O1A, O1B, EB1 that our clients can use as a reference to see all the information that's required. Because if you give them a letter that just has one or two of the things required, they will not accept it, right? You have to understand, people need to understand this. They are not going to go out of their way to connect the dots. You have to connect every single dot in the petitions. So you need an attorney letter that explains the evidence, why it falls under these categories, why it qualifies, and then link everything together in terms of the exhibits. You can't just have hope that they will do it for you. We've been through a Trump administration already. So I can say now with more experience that there is absolutely no case that will be just awarded to someone. You have to earn it, right? So with awards, the good news is they've highlighted the kinds of awards, but what you're looking for is strong institutions with long history and previous prestigious winners, specific criteria for granting those awards. So not funding. These are individual awards.
Yeah, definitely. That's kind of like, I think, kind of like a very recent change, which a lot of people don't know about. And I mean, getting RFEs and getting denials because of that. So that's like for the award. We talked about critical role. The third one, let's talk about membership. I think people used to apply with like, YC as a membership at some point, and but I think I also heard about that, like, even the membership needs to be very, very well defined. Like some, so I mean, I'm interested to hear your thoughts, what you
Yes.
are seeing.
Yes, you're right. The problem with YC, there's a few problems that were happening before. I think those were fixed. I'll explain. It's an accelerator and it also invests into its members. So because they're going away from funding now as anything but proof of distinguished reputation of the company that's part of the accelerator or part of the program, you don't want to include it. So what happened? I had about 7 or 8 cases at one time that had YC members. We were getting pushback from immigration. I worked with YC, with the founders of YC, to re-engineer their letter. So the template that I came up with was eventually utilized by YC. It's used by YC for all their people now. And the reason why it's working now is because it's geared with only one thing in mind, which is to qualify under membership. So it removes any discussion of funding. It removes the mention of the organization being the member, but it focuses on each founder. So if you have 2 or 3 co-founders for O1 cases, separate cases, they're being mentioned individually. So I was able to show them that they really needed to make these changes, and I'm happy to say that I was successful. So for now, we've been presenting YC as a membership only, and it's been successful. We don't know now with the new administration how that will be. We might have to have this, another one of these in a month or two if there's a lot of changes in how they're interpreting it. But what's important for people to keep in mind is that they need to be professional associations or they can be fellowships. Fellowships always have a very high standing in the eyes of USCIS, but those letters need to show the specific criteria used. And because they're so literal with the statute now, which says something like, as judged by recognized national or international experts in their disciplines or fields, I think that's the language, you have to include a list of 4, 5, 6 members of the selection committees and give a little brief bio. So, co-founder of this company, did this, did that. We even include the LinkedIn profile sometimes for some of those people who selected the members because that's exactly what the law asks for. And maybe in the past they were a little more loose with the interpretation, certainly under the Obama administration, but now they want to see all those important factors in the letter. So you have to prove. There's a really interesting update, though, which I want to tell people about. They have listed specifically two organizations as examples that they believe meet this test. So let me see. So the first one is, and we've used this for some of our cases, it's the Institute of Electrical and Electronics Engineers, IEEE, is specifically cited as one that can be used for membership. And then the other one is called, I haven't memorized this yet, it's the Association for Advancement of Artificial Intelligence. So they said before they released this new guidance that they would be focusing or giving more emphasis on technology fields. And this is where they have officially incorporated it now into the policy manual. So that's kind of a hack for some of our viewers, I guess. If you qualify for one of these organizations or both, you should definitely apply because they have said these specific ones work, and rarely do you see guidance that gives you a direct answer, right? So for people who are a lot of our clients, let's say from India, China, have engineering degrees and they go into the AI related fields, right? So that gives them two bites at the apple. If you can get these, that's certainly something that you want to try to do.
Yeah, and I think that is like one part where we also help people in able to identify which membership might qualify, right? I mean, I mean, these are like very complicated things, and it's more about like being able to figure out the right ones, right?
Yes, and I think YC was a good example because it used to work for funding for awards, and then there was a shift. So if the people out there are looking for someone to work with and they just do this sort of plug and play where they're not up to speed on all the changes, then all of a sudden you're going to get a request for evidence. When you get a request for evidence, they start digging into other categories and trying to poke holes in those. So fundamental mistakes like that, not knowing the way things are trending, means that you're putting yourself at risk. If USCIS, like in this case, mentions two specific organizations that could qualify you for membership, then you should absolutely try to incorporate those, right? So you have to make sure you're always working with someone who's day to day seeing the changes that are happening.
Definitely. I know there are a lot of questions in the chat too, and we will get to it. And I know we have just 30 minutes more. So maybe I want to like, start going more and more into the other criterias. Um, Published material, I think published material, like, some people think like, okay, can my blog on some website can work as well or not? So what's like your thinking about published material and all?
There hasn't been a lot of change. I'll just let people know. So first of all, I'll reiterate, media is the most important category you can use. It legitimizes, it gets you the qualification in one of these, in the category, one of the three criteria, right, that you need minimum. It legitimizes the other ones because if the article is well written, it's a profile piece about you, and it talks about membership in this organization, judging in Stanford Tree Hacks, being a part of IEEE or having a critical role at your company or companies. it legitimizes all the other categories. So that makes it like two, it's almost two as opposed to one. To me, it's by far the most important ones. And you can access, ways to get things published. Because unlike when I started, when a lot of things were published physically, now the new guidelines say specifically online publications. And that's really important because it used to just say publications, and the meaning was, the interpretation was that it was just physically published material. Right now, it's expanded to include online publications about, and this is important, about the applicant in his or her field of work. It can't be like one case we had where the person was a drummer and she was a model and she wanted to, she was in this important magazine for model about modeling because it wasn't her field of work. We were applying as a musician, right? So it has to be in your field of work. If you're multi-talented but you're in AI and you were a biologist in a previous life and there was an article about you in biology, you can't use it. So that stayed the same. And the last thing is now, because, and I haven't tested the waters completely at all, but it used to just be TV or radio, but now I think if you can show that you were part of some major broadcast, including a podcast, what you need to show is the reach, the number of listeners, and you need a transcript of the entire interview that you did to see if you can use that as well. So it's expanded a little bit in terms of its interpretation. It's not just published media now, it's also major media of different forms. So I can't underscore this enough. They will not take you very seriously overall if you have no media coverage about you.
Got it. Thanks for sharing that, Steve. The next criteria maybe we can go into is judging the work of others. I mean, there are hackathons. Like, what do you think like can count into this?
Well, they've enumerated a little bit more in the guidance what some of those are, and ironically, it does not mention competitions, but we use competitions all the time. So if you're going to use a competition, it has to be number one in your field of endeavor. So we use computer science a lot as a broad field for people, and then anything related to computer science, hackathons that are AI related or not, they can be used, but it all depends on the reputation of the organizer. So if it's a hackathon that nobody has heard of because they're so ubiquitous that every university and country and state and city has them, they have to be the prominent ones. So, there's one for University of Michigan, there's Penn has one, there's Hack Harvard, there's MIT Hacks, there's the Stanford Tree Hacks, there's um, Berkeley AI Hackathon. Those are the ones we use the most. You have to show that the organizer is legitimate and has a distinguished reputation. Most importantly, that it's national or international in scope, and that it's not just for students. So people have to understand that this is where you're on the fence between student and professional. These are professional level visas. They're work visas, right? So it can't be a math competition you won, the National India Mathathon or whatever when you were 12. It's nice for background on the person, but it has to be something that's professional level, right? They also specifically quote peer review, and I think people underlook this category, probably because it's harder to get. But if you are reviewing abstracts or papers for scholarly academic conferences, if you review articles for scholarly publications, if you're what's called a member of a dissertation committee, let's say for these PhD candidates that we talked about, or you've done any peer review of government research funding programs, and there's not that many people that might have that experience, but we don't want to think people to think that it's only hackathons. If you do peer review, which requires a lot of work, but if you went to university and you say to them, I want to be a peer reviewer for your conference, for your academic publications, and they say yes, you have to put in the work. But it's a real sort of stamp of legitimacy when you get a certification or a confirmation letter from a University of Pennsylvania or wherever you went that says you reviewed academic papers for publication. So I
Got it.
think we,
Yeah,
we should emphasize that if you write or if you review scholarly articles, you can qualify, right? There's two categories for that.
got it. Awesome. The next one we have here is more of like the original contribution. I think as a startup founder, some people can like prove that, okay, this is like my original thing. But how can people who have been like, maybe on H1B for a while and trying to prove that O1, like towards O1, like how do you see like original contribution criteria be met?
Well, this dovetails sometimes with publications, right? Of scholarly publications, which is something we'll talk about. If you have published material then that espouses new hypotheses, or it has ideas that are new, or it talks about something that you've designed or created, or revolutionized, then that's a way of legitimizing it. If there are articles about you, for example, that this dovetails with media. Like if you've created something, let's say you created code that was implemented in a certain way, okay? Just because you did it for the company you're working for on H1B doesn't mean that you can't prove that it's had an impact on the field. And I think that's really important distinction that I have to teach my clients over and over is critical role is about impact you've had in a specific organization, right? But you can simultaneously have created something that's original that impacted the field. And that's where you bring in subject matter experts to give their opinion and confirm that what you created had an impact. If it's been cited, if you've published papers, white papers for conferences or scholarly articles, that dovetails with another category. This does not apply at all for people who just put their nose to the grindstone and just crank out work, right? Because it has to be original. Most people don't have patents on things when they work, but we're doing a case now where the person has 4 active and 8 uh, pending patents that they've created while working under H1B for a major company. But his name is on those patents. So now all we have to prove is the impact. So what was the impact? Is it measurable? So if you get letters from government organizations, from other companies that are using the technology or whatever the person created, if there's evidence of the commercial use of the work, um, all of that contributes to showing originality and impact. But remember, it's impact on the field. If it's all just putting your nose to the grindstone and doing work, then it's only going to be useful for critical role letters about the impact you had internally at your company.
Got it. So original contribution definitely is hard. I think I like the fact that you said like published material can be like more of the leading from the front, which I think maybe a lot of people do have misconception around it. So I like thanks for sharing that. The
You know,
next criteria, go ahead, go ahead.
yeah, one thing I
Sorry.
want to say is that we're living in a different time now where there's almost unlimited bandwidth in terms of publication. That applies to people getting articles about them because these websites like a Forbes or whatever have unlimited space now. It's not just a published journal now. The same goes for journals, right? Academic journals. They're starving. If you talk to people who run these journals, they're starving for people to write great content because then it's cited and it gives more prestige to that university or that organization. So if you're a person who has things to say that are high level, that's what they're looking for scholarly articles. And then the way to legitimize those articles is where they're published, right? If you, like you said in the beginning of this, if it's just a blog, it might be high level, it might have citations, it might have index and who knows what. But if only 4 people are reading it and it's not legitimized by a third party and published through their platform, then it's not going to work. So there are websites where people can publish things. Those are not critiqued, and they don't have a stamp of approval from the organizer or the publisher or the university or the professional association. All of these criteria, what I call third party validation, right? The adjudicator is not going to take your word for it that you were critical, or that this company's distinguished, or that this article is scholarly. They're going to look at the reputation of where that information comes from, or where it was published in this case. And so people who are really wanting to build a strong O1 and potentially EB1 case, they should put their thoughts on paper and have something new to say with citations, not just publishing on LinkedIn, but looking to publish those fleshed out articles in important, well respected professional journals. And last thing is it can also be published if you get published in major media, like a Forbes.com, which I mentioned, and you're a business person, and you write about business and it's high level, that can be argued to be a scholarly article in major media. So there's a lot of different places where you can place it, but you have to create really good content to be able to qualify here.
Got it. Awesome. The second one, the next, I think there are two more criterias here. One is authorship. So how does the authorship criteria overall works
Yeah,
of
that's the one.
authorship of scholar? Mhm.
Yeah, that's the one I just talked about is scholarly articles.
Okay. So just like overall get it, I think sometimes people get confused between published material about them and authorship of scholarly articles.
Yeah, I
Like
mean,
if they are writing,
so let me make it very clear. They're completely different things. One is by and one is about. One is active, one is passive, right? If it's about you, it's about you and you didn't write it. If you wrote it, it's about something in your field that's high level. It's scholarly, right? It's like I'm an expert in this. Here's my thoughts and citations about this research I did or this code that I wrote or whatever it is that contributes something to the field, and the stamp of approval is because it is published in a professional journal or major media. The other one is completely, let's talk about Atal Agarwal and how incredible he is in as an entrepreneur and his whole career path, et cetera, in India Outlook or India Times or some important Wired or whatever it might be, right? That is about you. There should be no confusion here. They're completely different. You can get articles written about you, but you have to produce, which is what I was just saying. You have to produce the work that is published by you, right? It's by you. It's complete opposite end of the spectrum.
got it, very cool. I think the last criteria here is the high salary one. And I think maybe like, I think what I see as a confusion people have is like, okay, can this, like, if I'm paid like 300K, does that qualify or like 150K qualify? Like, how do you say like, how to qualify for that?
Yeah, I'm very ambivalent about this category because I've seen so much pushback on it in the past, especially when it comes to EB1 cases. But the guidance now is interesting because, and one day maybe we can do an EB1 one. But what's interesting now about the guidance is that it seems to amplify or make it a little wider now. It specifically mentions the BLS, which is the Bureau of Labor Statistics, as an authority for this specific category, which is interesting. And then it also mentions something called the Career One Stop, and that only has like 600 professions on it, so it doesn't include all these things. Most important take home for people is when you are figuring out whether your salary is in that top 10% or not, it's all defined by the field, right? So this is a trick or a trap, sorry, that people fall into when they don't get the right guidance. If you're going to be the CEO of a company, right? And your sponsor is your company you founded, and you say I'm going to be CEO and make 300,000 as future work because the statute says has commanded or will command a high salary or other remuneration, right? So if you frame it as CEO, you're being compared with the Bill Gates of the world. You're not gonna measure up because there are CEOs that make millions and millions of dollars. But if you are, let's say, an AI engineer and your position is AI engineer that you're projecting in the contract, then you're compared to other software engineers that are probably in like the 200 to 220 range, 90th percentile. And if you know what that is in its future remuneration, then you can project above that. The trick, of course, here is you have to pay yourself that salary if that's what you're projecting for the future. For past remuneration, you're compared to people in your geographic area, same position, right? That means that if you had a really great job and you were making three times what everybody makes in China, as long as you can access reliable data in China or whatever country you were working in that shows what people made in that profession, that position, that year, you have a case also. This is not confined only to US salaries. The only problem here is how authoritative is the source that you use. So the more official the information is, like citing, like they do their own Department of Labor, if there's a similar organization in the UK or Germany or places that are pretty advanced with this, then you might be able to use that as well. But you have to know what you're comparing yourself to, and in order to know what you're comparing yourself to, you have to know what your position is and what field it is, right? So people cannot fall into the trap of saying, I'm a CEO in the future, then you're comparing yourself to salaries that are way above your pay grade, and you're not going to be able to qualify.
Got it. I think we kind of went through pretty much like all the different criterias for O1 now. I think maybe like, I see some of the questions. We can start taking those questions.
Let's take some,
Uh,
you can choose them. Let's choose the questions that are more general so they're useful, the knowledge is useful for everybody as opposed to I have a specific situation.
so I think one question I see is what if anything has changed with President Trump is changing.
Well, I think we've gone through some of the new guidance. It's interesting, the guidance went into place 12 days before President Trump came into office. So, what I would say on that one is let's wait and see. We had a lot of pushback under the previous Trump administration. So, whereas, for example, during the Obama administration, I had zero cases denied of any kind for 8 years. Under the Trump administration, the number of denials overall was about 4 times what it was under Obama. So I think people need to understand that they can't rush these petitions. They need to use the guidance and they need to build cases as strongly as they can. I don't like to submit a case until I know there is nothing left to add, right? I think that's the most important take-home message here with this administration is there will not be easy O1 cases.
Got it. Definitely a lot of questions here, and I think around like more than 500 people are watching it, 300 people on just Twitter, and then probably on LinkedIn too. So we'll keep like more and more of the general questions which are relevant to everyone. Uh, this person says like Jan 8 stuff was confusing while previous O1A details seemed easier to understand. Was it like Jan 8 is when the guidance was released? Something around I think
Yeah.
founder.
I would disagree with that. I think that they are trying to go into more details. The guidance itself points you in the direction of changes. So it says, see section this, chapter that, subsection this, this was modified. What people need to do is look at the policy manual itself. Because I've worked with the what's called the adjudicators field manual in the past, the law itself, something called the foreign affairs manual, all these different things were sort of brought into one place. And that's the policy manual, and that's evolving. So because I'm familiar with the policy manual, these changes I can see them just by looking at them. Most people would not be able to understand how it's applied. And so I think the thing you should do if you're confused is not try to figure it out yourself. You need to work with someone who knows exactly what it means, how to apply it to build your case in the best way possible.
Got it. Um, I know there's next question is like about this sole founder thing. I know you mentioned like there is definitely a new guidance. Like what do you suggest like someone who's like thinking of being on a solo founder route?
I think that the most important thing here is the funding aspect. I talked about the ability to pay. So their chief concern now, if they're not focusing on how many people own the company, is going to be can the company pay the salary? Because if you're sponsored by a company, you are required to stipulate a salary in what's called the I-129 form. That salary, once you go into O1 status, is required to be paid, and it has to be a reasonable. There's no minimum number really, because Department of Labor has no role in this like with an H-1B. But let's say you're going to pay yourself $100,000 a year. I haven't seen this yet at all, but it's very possible that they could say, please show us that the company has the assets to pay this salary, which means you should have sufficient funding when you submit the case to make sure you can pay whatever that salary is. I think that's the one sticking point that could come up because these companies may have no net or gross, profit or revenue to date because they're brand new. That means that at least, at the very least, there should be enough assets. So make sure that whatever you're going to pay yourself, you have more than that in the bank account for the founding or for the sponsoring company to be able to pay that salary.
Got it. I think next question I think since O1A agent is also a topic, I'm gonna pick
Yeah,
a couple of questions around O1A agent. This person
sure.
asked like I was told my Canadian company can sponsor my O1A as long as I have an agent in the USA.
Yeah, that's a really strange one. I think that's where you're going into gray areas. I would say that the traditional ways to do this are the following. You have a corporate sponsor, which is your employer that you don't have a stake in. That's the traditional one. The second one is you are a founder or co-founder and your company sponsors you. And the last one that I use where I don't feel like I'm going too much into the gray areas where you have a US citizen individual, what's called visa petition agent sponsor. And that person co-signs future work contracts that you use to fill up the time to be able to justify the 3 year period for an O1. That means that person going forward, if you then work on other projects, needs to co-sign contracts for that future work. I think in this case that would be simpler than using a Canadian company and throwing that into the mix too, because if you have the visa petition agent, you don't need a foreign company to be involved in it at all. And so I would steer away from that one because to me that's blurring the lines. I think you should try to use one of, so if you have a visa petition agent possibility, and I know we were going to talk about this at all. So the advantage of that is that you're not tied to one employer. If you're tied to one employer, as has happened for dozens of our clients over the years, and they give you what's called a pink slip, they say in 2 weeks you're off our payroll, you're fired or you're downsized or whatever it is, you have to scramble and in 60 days time find a new employer. So if you have a visa petition agent, which is anyone that you trust who's a US citizen preferably, that person can co-sign the contracts that you start with. Those have cancellation or what's called rescission clauses. If you don't end up working for those on those projects, it's okay because as long as you have that visa petition agent sign new contracts while you're in O1 status, you are authorized vis-a-vis that person to be able to work. And that gives you full flexibility. And that can include a company that you found also. If you need to make money with one company and also co-found another one, as long as it's all signed through your visa petition agent, you're free and clear to do what you need to do or what you need to grow your business, pay your bills. That is the best option for a lot of our clients. And I've never
See,
seen, almost
yeah,
never seen that question. Now, let me just say one more thing, that's all. USCIS has created a deal memo or future work contract template. And we've been using that since it came out. And you just modify it as needed to fit the period, the compensation, the employer, scope of duties, all those things. You can modify that one page thing to create a contract for each one.
got it. I think one question that a lot of people have is like, if let's say they end up like, let's say getting O1A agent and they have multiple employers, like, right, they are working with via the agent help. If let's say they end up changing it a little bit, like, they find another person who they want to work for,
Yeah.
um, do they need to go through the filing again or
No, no,
it
no.
can.
So it's very hard for people to conceptualize this. Once you get O1 status, your sponsor is that person, that visa petition agent for that period of time, which is usually 3 years. If you want to take on any work whatsoever, the only thing you need to do is sign a new deal memo or a future work contract, and they co-sign it. So it'll have project employer, it'll have applicant or visa holder, and then it'll have visa petition agent. They sign that, that authorizes you to take on that work. So their only requirement going forward is to sign future work contracts once you're in status. They are not required to find you work, and they're not required to be paid something either, right? They don't have any proactive requirements. The only thing they have to do is co-sign any work that you do. I don't ask my clients if they're signing these deal memos each time they get work. They know that they should be, right? When you go for an extension or you want to go for an EB1, you have to show that you're maintaining status, which means you need to be getting paid, right? Before you apply, you need to show pay stubs to show that you're maintaining. But that can if you that can come from essentially any source once you're in O1 status through a visa petition agent, as long as they co-sign whatever projects you're going to be working on. So you don't
Got
need to
it.
do any new petitions of any kind.
Got it. Awesome. Thank you, Steve. I think one question I see here is like more around doing it via agent route versus their own LLC. What do you feel like is like the big difference between if you file via an agent versus file it through your own LLC?
Well, if you file through your own LLC, then you can't take on other work, right? You would have to almost work through your company. So let's say another company wants to use your services, you couldn't be able to work for them independently as a what's called a 1099 contract worker because you are sponsored by your company and you're getting paid a salary by your company. You can't have both. I always say this to people. You can't have full-time employment with your company and independent contractor possibilities. You have to choose one or the other. You can't be independent and dependent at the same time.
Got it. I'm gonna take like maybe one or two more questions.
Sure.
One another question is like, could we do O1A to EB1A basic, and how much harder is it to get EB1A in comparison to O1?
Okay. EB1A does not require an O1. That's a myth. So you don't, in order to qualify for EB1, you don't even have to be in the United States. We just got an EB1 approved for an architect who had never lived or worked in the United States. They went directly to green card, okay? But that's because they were a superstar. They'd been at the Venezia Biennale, won awards in architecture at the most important, published, you name it. They had like six or seven categories. You have to be a superstar to qualify under EB1. We get pushback regularly on cases that don't have Grammys, Emmys, Oscars. If you don't have any of those, which means you qualify automatically, you have to prove essentially that you were in that top 1 2% of your profession. And so most of our cases are O1 because it has a lower threshold, and then there's a period of 6 months, a year, whatever it might take to make their cases infinitely stronger. Because EB1, even though it looks the same, the number of people that get approved is infinitely lower. And I can't tell you the legal justifications for that. It's very frustrating because the language is the same, the categories are almost the same. Um, but the threshold to get into EB1 status is much higher. And so you need to work with someone who knows just by feel and touch and experience how much more you need to get to EB1. But you do not need to go to O1 before EB1. So we're doing EB1As for a lot of Indian clients that are in L1, they're in H1B, they've never gone to O. What O gives you is the freedom to not depend on an employer. And then you can get EB1, but it's not required for EB1 to have an O1 previous to that.
Got it. Awesome. I think one last question here is also related to O1A via agent route.
Mm-hmm.
Is like, can the can the jobs that people have like via O1 agent, can they be from the different fields, like not in the same field? Like, how does that work?
So when you present the case, everything, we talked about this from the beginning, the first thing you do is define the field of endeavor, right? Because you're extraordinary in one specific field, it's computer science, business. From there, the contracts that you sign that have scope of duties to secure the O1 status should also be in line with what you do. Because if you're an AI engineer, then the scope of that position for that project will be AI engineering consultant, right? It will be related. It can't be gardener or baker or things like that. Once you're in O1 status, there are no checks on what you are doing. The only requirement is that it's co-signed by the visa petition agent. So like I said, I don't have the time to follow up with my clients and see what they're doing. Once I've gotten them their status, usually we're just working on EB1. We're not thinking about, analyzing all these other things. But I think that in good faith, in the spirit of the visa that you have, you should try to stay as much as you can within the field that you've proposed.
Got it. Awesome. I think we're pretty much like, done with the time. Thank you, Steve. For anyone like, who's looking for help on any of these visas and have more questions, like please reach out to us. And I think Steve would be happy to, answer other questions. Steve, anything else you want to add? I think there are a lot more questions in the chat too,
No, I
but we
think
can
I
figure out later.
think that the recurring theme here is that this is very complex. So don't try to figure it out yourself. And if you have the option to not work with sort of a cookie cutter agency that just cuts and pastes things into a petition and doesn't have an attorney of record that's advocating for your case, then the chances of success are much lower. It's important to work with whoever you choose, somebody who lives and breathes this every day and understands the things that I'm talking about, the changes, the tendencies, the trends, because you have to modify and evolve in order to survive and be successful in this field. And this is your future that's on the line. So you want to make sure you're doing it 100%.
Amazing. Thank you so much, Steve.
Thank
We will
you.
have we will have more sessions like, around different topics. So please reach out to us like if you need any help. I think by the way, like we covered a lot of ground today. So thank you to all the people who joined, and thank you, Steve, for being here.
Thank
We will
you.
meet again after a couple of weeks. You will be updated. Thank you.
Thanks. Thanks. Bye, everyone. Thanks for attending.
Okay, hold on, Steve. We need to get this uploaded 100%. So I have the
Yeah,
recording.
sure.
What do you think? How did it go?
Went great. We'll just
Right?
we'll have to do a follow-up one because there's maybe if people send questions, we can just come up. We could do like a Q&A